Good afternoon, everyone. My name is Mark Tarbox. I am the Director of TAP Education at the Eviction Defense Network, and I'm here with Estrellita, and we're holding a class on how to respond to discovery requests. And today's class is going to cover mostly form interrogatories, unlawful detainer, and how to respond to those questions, what those questions are asking you. However, I am not an attorney, and there is no legal advice that will be given here today. I can talk to you about the general eviction process and what these questions are asking you, but I cannot answer any case-specific questions about discovery. And the first thing you should do when you receive discovery requests is request an extension from the opposing counsel. And you do this by emailing the opposing counsel, letting them know you received the discovery request and that you want to answer the questions thoroughly and gather all the evidence that they're asking for. And you believe that it will take you 2 weeks to do that. And you can request a 2-week extension. And you should request an extension 2 weeks from the original deadline. And the original deadline is 5 days. So you want 2 additional weeks to respond. And you're also going to put that you want to preserve objections with your responses in that time. And then you're going to wait for the attorney to respond, either granted, denied, or something in between. And you're going to also let your attorney law clerk know. You should have an attorney law clerk team. And you should, if you don't know who your attorney law clerk team is, please come to our tech classes Monday, Wednesday, 4 o'clock, and also Saturdays at 8 a.m. And you'll be assigned an attorney law clerk team. And you want to send your updated personal information paragraph to your attorney law clerk team, letting them know that you received discovery responses and when they're due. Let them know if you requested an extension and how the opposing counsel has responded. Someone has posted in the chat, can we get discovery help at a self-help center? Sometimes they give you the forms, but I don't believe they assist with the responses. If you have received requests for admissions as part of your discovery, and discovery usually can include up to 5 different types of discovery. There's 2 different forms of form interrogatories. There's special interrogatories, just requests for admissions, and also requests for production of documents, also called demand for inspection and copying. And you could receive all of those or one of those or something in between. And whatever you received, you're going to communicate that to your attorney law clerk team. If you have received admissions, which is likely, then your law clerk is most likely going to be the one who assists you with those responses, because it's very important that those get responded to quickly and on time, because you don't want to get a motion to compel on the admissions. What the attorney for the other side, the landlord, will want to do is they'll see that you didn't respond to the admissions, and then they're going to ask the judge or commissioner to rule that because you didn't respond, that all those questions should be given an answer of admit. And if those answers are deemed admitted, then the landlord's case is won, and they will then file for motion for summary judgment, and you'll lose your case. So you don't want that to happen. And we're here to help. And so if you've received a packet from Discovery, number 1, request an extension. Number 2, you're going to contact your attorney law clerk team and let them know you have discovery requests. And be sure to indicate which types of discovery you received. The packet, if you look at the pages, right, the first page of each section tells you what type of discovery that is. So you'll see at the top left, we'll have the information from the attorneys of the landlord. And then below that, it will say plaintiff and defendants in the caption page. Over to the right, it will have your case number, and it will also explain what it is you've received. So it will say something like request for admissions, for form interrogatories, unlawful detainer, could be form interrogatories general, special interrogatories, and or requests for production of documents, or some firms call it demand for inspection and copying. And request for production of documents and demand for inspection and copying is asking you to produce your tangible evidence to back up your answer. Like when you submit your answer, you're saying, here are the reasons I believe I'm protected or defended against the eviction. And you need tangible evidence to back up those defenses. And that's what they're asking to see. And that's what they're entitled to see. Both sides are entitled to see the other party's evidence. And so they ask questions about your defenses. They ask questions about your evidence. They ask you produce evidence. And you can also request the same from the other side. It's called propounding discovery. However, you have to do it timely. You get a very short window to request the discovery. It has to be done before the first appearance, and you have to give them 5 days before the first appearance for the discovery to be due, and a minimum of 5 days, calendar days before it's due. They have to receive the responses. The requests, because you've got to give them 5 days to respond, and then from the date they're due, there needs to be 5 days before the first appearance. And so if you've received discovery from the other side and you don't have 5 days to respond and 5 days between the date to respond and the first appearance, then those requests are not timely and you don't need to respond to them. But you should still let your attorney law clerk team know that you suspect the discovery requests are not timely so that they can confirm that for you. And you're going to want to look at the date you receive them and how you receive them, okay? Discovery requests are often mailed overnight. And if they're mailed overnight, then the day you receive them is day 0, and then you count 5 days from there, 5 calendar days, including weekends. And then the 5th day is the date they're due. If the 5th day falls on a weekend or court holiday, then they're due the next business day. If the requests were sent to you first class, then you have 7 days from the postmark. Look at the postmark, and then you can count, that's day 0, count 7 days, that's when they're due. And if they were served to you in person, you have 5 days from the date that you're served. Okay, so I'm trying to think if there's anything else before we get started. Once again, I'm not a lawyer. I can't answer legal questions. We're going to start today with how to respond to the form interrogatories general, because we typically object to those. So I'm going to put them on screen. These are not commonly served because they're not typically used in unlawful detainer cases. That's why this form interrogatories unlawful detainer. Those are specific to unlawful detainer cases. The form interrogatories general are about other types of things, usually, like it refers to an incident, something that has happened, like a car accident, for example. And so I'm going to jump ahead just so that we can, because we usually respond to the form interrogatories unlawful general. Here they are, okay? So if you have the form interrogatories general, you put the person who's doing the specifically responding, right, puts their name and address up here. If there's more than one defendant named, more than one occupant of the unit named here, right? So there'd be multiple people's named here. Only the person that's responding to this discovery puts their name and address and phone number up here, and that specific person is the responding party here. Okay. You're going to put the plaintiff's name just like it is in the complaint. Exactly. Whatever it says there, that's what you're going to put. Make sure you get the punctuation, the spacing, everything correct. You're going to write, even if it's wrong, you're going to write it just the way it's indicated in the complaint. And you're going to do the same thing for the defendants. You're going to put all the people that were named. If it's just one person, then just one person here. If there's multiple people, you put all their names here. And again, if they're misspelled, you put them how they're misspelled here. You're going to put the case number just as you see it in the complaint. Here is the propounding party. You're going to put in exactly what you put here. You put here. Responding party is the person, the specific defendant, only one person here. If the name is spelled incorrectly here, you can correct it here. Put it how it was incorrectly written here. Then put sued herein as, and then put the correct spelling. And then what we've got here is a statement written by the EDN attorneys that the defendant objects to the use of the form interrogatories general and that they are not designed for use in unlawful detainer matters. You sign and date it, and you want to send this in within the original 5-day deadline. You can send it in within the extension deadline if and only if you requested that they preserve objections and that request was granted. Okay. Otherwise, you're not allowed to object and you need to answer those questions. You don't want to have to answer the generals. So the best way to get this, to avoid that, is to get this filled out, signed and sent with the verification signed and sent, and the proof of service signed and sent. If you let your attorney law clerk team know you received interrogatories general, they will likely sign the proof of service for you and help get this out to the opposing counsel within the deadline. They're not always available, though. Sometimes law clerks are extremely busy and they'll ask you to do this yourself. If you do it yourself, make sure that the person who does the proof of service, this is the person who's going to email this to the opposing counsel. You're going to make sure they fill this out properly, starting off with the fact that they are a person 18 or older and not party to the action. Okay. They're going to put in the date, which should be the date they put in here should be the date that they are sent. All the dates should match. The dates here, the dates here, all the dates should be the same. It should be signed, dated, and sent on the same day. So they put their address here, the date they sent it. They should check the box of how they're serving it, most commonly via email. The email address is usually at the top left of the document. If not, you're going to have to find out what the email address is for that law firm. And we often have that information if you ask the law clerk team. And then date and sign here. And then we're going to skip down to the request for production of documents. Okay. Request for production of documents, they can ask an unlimited number of questions, right? But the response to all those questions is going to be pretty much the same. It's basically going to say, if I have the documents that you're asking for, the evidence you're asking for, it can be found in my binder. The caption page is very similar to the one that we just reviewed. Fill it out the same way. The person who's responding, name, address, and phone number. Plaintiff, exactly like in the complaint. Defendants, this is all the people named here. The case number here. The plaintiff here. The specific person responding here. And then these responses, if you're sending the responses within the deadline, you can check this box, preserving the objections. Otherwise, if you're going to send it after the deadline, check here, waiving all objections. It's important to note that it's not necessarily the end of the world if you send responses after the deadline. However, at any point after the deadline, the plaintiff can file motions to compel, and motions to compel can come with sanctions. And a motion to compel hearing is usually scheduled out based on the availability of the court. Sometimes it can be sooner, other times later. Often it's like a month away. And it's a separate hearing from your trial hearings, like your pretrial hearing. So a lot of people think, oh, but I've got a first appearance coming up next week, right? But I haven't got my discovery done. Am I going to be in trouble in my first appearance? Not likely, because the judge or commissioner probably doesn't even know you were served discovery. And the judge or commissioner typically only rules on motions. And so the attorney for the landlord must file a motion, or the landlord files a motion to compel you to respond. And that has a separate hearing that is scheduled, and you appear at that hearing to either say, I complied and answered all these responses, and you oppose the motion to compel, or you give some other explanation for why you haven't responded yet. You can be sanctioned, so it's important to try to get these done as soon as possible. Okay, so back to the request for production of documents. There is a specific request in each one of these, right? So there'll be a request number 1, request number 2, and they're asking you to produce certain documents. And it doesn't matter what those documents are. Whatever those requests are, you're hopefully going to have evidence to support your defenses and put them in your binder. These are the most common categories for exhibits in unlawful detainer cases. And so you can just leave in this response here that basically tells the landlord's attorney that's reviewing your discovery responses that whatever the request is, you most likely can find it in one of these categories in my binder, which has been scanned and attached with these responses. You don't have to put the question in here. You don't have to change this in any way. It's designed for if applicable, okay? So if it's not applicable, it can be ignored. So if it's applicable, it's here. If it's not, ignore. And if you have certain documentation that you're expecting that hasn't arrived yet, this sentence at the end covers that. This was written by the EDN attorneys, so it's something that you should review and, of course, make sure applies to you, and get your binder, all your evidence, your tangible evidence. This is written communication between you and the landlord or the property manager, photographs of any bad conditions, habitability problems with the unit or in the common areas. You're going to have your copy of the lease in here, your history of rent payments, and get those all in your binder. All the defenses you raised in your answer, you want to support those with tangible evidence, and that's what you're putting in your binder, and that's the response to the request for production of documents. And so you might receive 50 requests for production of documents, or 4 or 2 or 12, whatever the number is, right? You're going to eliminate the ones that don't apply. So if you received only 8, then from 9 on, you can delete, and then just make sure you delete only up into where you sign and date, okay? So this has got to be left in. This is where you sign and date. And then you also have to sign and date the verification page. And then once again, have someone else who's not party to the action serve these to the other side, to the landlord's attorney. And you're going to want to try to do it as timely as possible. knowing that it can take a lot of time to get all the exhibits together. That's why you're requesting an extension. But try to get all of this done within the extension time, because you're also going to want to have your binder ready for your first court appearance. You want to make sure that your binder is in the best possible shape, because in some instances, in some courts, they're moving really quickly, and you could be asked to merge binders sooner in the process than previously requested. So you want to have your binder in the best possible shape as soon as you can. And then once the binder has been completed, you've hopefully requested a step 10 review with your attorney law clerk team, and you've had that reviewed, any notes addressed, it's now updated, you're going to get it scanned. Perhaps you have time for a step 15 review to have a final review, but you want to get it scanned as soon as possible. Either yourself or the EDN office can do it for you. Scan it as one PDF that you attach. You must send the binder, the PDF of the binder, the scanned binder, with these responses. You can't send them separately. They've got to be sent together, because basically the responses say, look here. And if the look here is not attached, then it's basically pointing to nothing. So you want to make sure when you send the request for production of documents, you send them with your scanned binder. And you leave in as many of these requests as the number of requests that are in your specific packet. Okay, moving on. We're now going to go to really quickly, we're going to touch upon the special interrogatories. Special interrogatories are interrogatories. Interrogatories are basically questions asking, an explanation. You fill out the caption form just like we discussed before. And you deal with the objections the same way. If you're within the deadline, you check here. If you are sending them your responses after the deadline, you check here. Not everyone receives special interrogatories. Don't worry about it if you didn't get them. They're usually questions that are specific to your case. So the form interrogatories, general and the form interrogatories unlawful detainer, are written by the court. They're not written by the landlord's attorney. So if you get form interrogatories, which we'll cover next, and you see those questions, don't be thinking the landlord's trying to, stump me or do something mean to me with these questions. They didn't write them. The form interrogatories are written by the court. They are the same for everyone. So everyone gets the same form interrogatories. The only thing that's different about the form interrogatories and the form interrogatories general is that the landlord's attorney or the landlord checks the boxes they want you to respond to. You don't have to respond to the ones they didn't check, only the ones that they checked. And we'll get to those next, but I just want to quickly touch upon the special interrogatories, because people do often get them, especially from the block firm, and they write in a question for each one, and you should put the question for the special interrogatory here that they ask. You can copy and paste it in. And then if you're within the deadline, you can leave in the objection. If you're sending them after the deadline, you're going to remove the objection, right, up to this point. You can leave in this paragraph, right? And this paragraph here, this last paragraph, remember, delete the objection, which is everything including here, because remember, it refers to the objection here. Remove this whole section, leave in this last paragraph for all the responses, make that the first paragraph of all the special interrogatory responses. And then this paragraph is basically saying, the answer to this question, whatever it is, may be found already in the responses to the form interrogatories, which I've also completed. It may be found in the evidence I provided with my request for production of documents, and you should look there too for an answer to this question. So it's basically saying you can look in both of those places for an answer to your question, but if the person responding knows that the question is asking for something that can't be found in either of those two places, then you should write that whoever's responding to the discovery should add to this paragraph a response that answers the question. Okay? And that's the same for all of these. And sometimes, a lot of times these are written to intimidate, harass. You see the question, it sounds intimidating, it sounds confusing. But if you read it over a couple times, you might realize it's a question you understand and sounds similar to a question you already answered. And so perhaps it is already asked and answered, and you can just leave this paragraph in. If you think that it requires an answer that's not provided already, either in the form interrogatories, unlawful detainer, or the request for production of documents, then you should add to this paragraph some piece of information that answers the question. Okay? And that's the special interrogatories. Once again, every section of discovery ends the same way and must be completed. And that is dating, signing, verification. There's a verification if you're English speaking. There's a verification if you, oh, where is it? There's supposed to be a verification page for translation. I'll have to add that. And then the proof of service. And the proof of service, you got to make sure that the person puts their address, the date they're serving, the means of service, usually via email, the date again, and their signature. And this person should be 18 years or older, and not party to the action. And if you can't find someone, you can always check with your EDN law clerk attorney team to see if someone at EDN can serve them for you. Okay, so that's the special interrogatories. I want to focus the majority of today's class on the form interrogatories, and I'm first going to show you what form interrogatories look like. If you have questions along the way, you can write them in the chat, and I will get to them at the end of class. I want to get through the whole thing first because I want to make sure we get all the explanation for the form interrogatories done, and then whatever time we have left at the end, I will answer whatever questions I can answer. I can't answer any legal questions about your case. I can only answer general questions about what the questions are asking you, how to respond. Okay. Okay, this is what the form interrogatories look like. They always look like this. They don't look like this, let us know. They should all have numbers that start 70 and above. They go to like 80 something, 81.3, okay? The first, when you see 70, right, that's the category, right? And all the categories are here. And then where it's like 70.1, 70.2, that's a specific interrogatory or question within that category. So the first category is general, and then there's questions about the notice, how the notice was served, etc. Okay. You should read the instructions here, especially the definitions for what each of these words means. During the course of the question, you'll notice certain words are capitalized and bolded. That means the definition for that word is in the definitions section 4 above. Okay. And like I said, these are written by the court, not by the landlord's attorney. The only thing the landlord's attorney does, or the landlord themselves does, is check the boxes for you to respond. You don't have to respond to any questions that are not checked, and you shouldn't. You should then answer all the questions to the best of your ability. For some of the questions, you might not be able to answer, and you should just be truthful that you're unable to answer because you don't know. If you do know, you should put in a truthful answer. And we'll get into the kinds of ways to respond to these as we go along. Trying to think if there's anything else I want to say about this. You'll notice at the bottom of the page, it tells you what type of discovery it is, form interrogatory as unlawful detainer. That's a good thing about court documents in general. At the bottom of each page, it usually tells you what it is. And so when an attorney or law clerk is asking you to find something in a document, look to the bottom of the page for helpful clues as to what it is you're looking through and save you a lot of time trying to find things. Okay. Estrita, you're here. I'm gonna make you a co-host so that you can let people in because while I'm talking, I often don't notice that there's people in the waiting room. Okay, next, we're gonna go over what we call the checkbox template. And I'm gonna put the checkbox template in the chat. While I'm getting this uploaded, I wanted to point out to everyone that not everyone receives Discovery. And so it's entirely possible that you're one of those people that didn't get Discovery for some reason. Basically, what happens is the landlord's attorney usually looks at your answer and decides if they want to propound Discovery to get some information about your defenses and to see your evidence, which they are entitled to see. You want to make sure that you don't be thinking, I don't have to do this. Why am I sharing my, evidence with them? I don't want them to know. I don't want them to know what my defenses are. I don't want to give them that information so that why am I helping them with their case, right? But both sides are entitled. Both sides are entitled to the other side's defense. You're entitled to the other side's explanation for any of the questions that you might want to ask them. And you're entitled also to see any evidence that you think they might have. And that they better respond to it just like you can. You can file motions to compel just like they can. And so you keep that in mind, but you'll also have to do it timely. You also have to know how to do it. And if not, get help from someone who does. And right now, the EDN staff is really, really busy helping lots of tenants with other matters. And so propounding Discovery, though it can be helpful, is less important than other things. And so sometimes nobody will be available to assist you with propounding Discovery. And very often, by the time you even ask us, it's already too late in your case because your first appearance is approaching. So if you do want or need to propound Discovery, make sure you do that early in the process after you've done your answer, more than 10 days before your first appearance. Okay, now I posted the checkbox template in the chat. It's a Word document, okay? The key thing about a Word document is that if you open up the Word document in some other software other than Word, it's going to break the hold on a second. Accidentally made someone a co-host. Okay. If you open up this template in something other than Word, even though it may look okay at first, it's not going to be okay. It's going to break the formatting, and the formatting is essential. It's required by the court because if the discovery is used during the course of the trial, they need to be able to refer to lines in the discovery, and those lines, they're numbered 1 through 28 on each page, are that's the formatting that breaks if you open up the software, open up the template in something other than Word. Okay. If you have Word software, you should be able to open up the document, make sure you have the latest version of Word or the version that supports the document. And if not, any other scenario, you should print out the template and fill it out by hand and then scan your responses and then send, okay? You want to make sure to preserve the formatting. And I'm going to put it up on screen and it'll make a lot more sense. So this is what we call the checkbox template. And it allows you to fill in the caption, just like we previously discussed. The person who's responding to the specific responses, excuse me, the request, puts their name, address, and phone number here. The plaintiff name just as it's written with all the same, any errors or punctuation, all here. All the defendants, everyone who's named is here. They are all the defendants named here. The case number here. The plaintiff again here. The responding party is the specific person, one person out of the group here that is responding. If there's only one person, then it's the same person. If they misspell your name here, you can correct it here. Put the misspelled version first and say sued herein as the correct spelling. Preliminary statement, objections. Again, if you're responding within the deadline, here, otherwise here. Next, here's where the questions begin. The formatting is over here, okay? So you see these numbers here. You open them in some other than Word. What often happens is these numbers jumble. They often go to the bottom. They'll all just drop to the bottom. There'll be a space up here, and only some of the information that's here will be on the page. It won't eliminate things usually, but it'll create many more pages. So almost like half as much information when the page is on the page. It's blank at the top, the numbers drop to the bottom. It's all a mess. You can't use that version in court. It will be rejected. So only respond on your computer if you have Word software, and if when you open up in Word, it preserves this formatting. It has to look exactly like this. The numbers 1 through 28, footer at the bottom, spacing all like this. The only thing that will change, of course, is as you add your responses, as you write things, then these interrogatories will move down. That's fine. It's okay for there to be more pages with responses as long as the formatting over here is correct. And initially, before you type in anything, all the questions should look exactly like they are right now in this, what I'm sharing on screen. Okay. So you should, if you're able to, you can do this you can fill this out while we go along. Put in your name, address, and phone number on the template here. If you printed it out, you can do that. You can write it out. If you have Word software and you're participating in this class, you can type it out on your computer and put in your address, phone number here, plaintiff here, like it is in the complaint, defendants here, case number. Propounding party is the plaintiff. Responding party is the specific person answering you. And then we go down here. If you're within the deadline, check general objections to all requests. Otherwise, if you're submitting your responses even just one day after the deadline, check here. Next, the first question is asking, did anyone assist you with the interrogatories? And when they asking if anyone assisted, they're prepared or assisted, they're talking about helping you with your answers, right? So we're providing you with a document only. We're not looking at your case information here. There's no legal advice given. So you can just say you can just use this response, right? Letting them know that the template was given to you, but no direct assistance, meaning nobody looked at your case information and told you, based on your case information, you should put in this answer. Okay. This is just a template for you to use. The template was written by EDN attorneys. I had no part in the responses. I'm just helping you understand what the requests, the individual requests, the interrogatories are asking you, and EDN has created a template with suggested responses. Okay, so the first one is easy. You can just leave this in here if nobody offered you direct assistance. If someone did look at your case and help you craft answers, then you should change this and put those names in. 70.2 is asking, is plaintiff an owner of the rental unit? If so, state the nature and percentage ownership interest and the date the plaintiff first acquired this ownership interest. Now, it's important to be 100% honest in your responses, because very often we think, oh, I think this is true, right? And people just say, yes, but do you know for sure? Have you seen something tangible to back that up? Because if you're not sure, then you should put in a response like this one: responding party lacks personal knowledge. If you know for a fact, not necessarily because someone told you, but because you've seen some evidence, something factual, right? Then you can check here and explain. Okay. So is plaintiff owner of the rental unit? You gotta, it's the question is asking you, have you seen the deed? Do you see that they own it? Do they still own it? Is it something where is it possible they sold it yesterday and you don't know? You have to know for sure. And if so, state the nature and percentage of ownership interest. If you don't know, right, and the date they first acquired this ownership interest, if you don't know, this is the suggested response. If you do know for sure, this is the suggested response. And that logic should carry out throughout these questions. Does the plaintiff share ownership or lack ownership? If so, state the name, address, and nature and percentage of ownership interest of each owner. Again, this is something you don't know. This is the response. Something you know for sure, you put here and explain. And remember, not all these boxes are checked, so only answers the ones that are checked. Form interrogatory 70.4 asks, does the plaintiff claim the right to possession other than as an owner of the rental unit? If so, state the basis of the claim. It's important to remember that these form interrogatories are questions and that are written for either the plaintiff to answer, the defendant to answer, or both could answer, right? And so it's important as you read the question to figure that out. Is this a question for me, or is this a question for the plaintiff? And if it's a question for the plaintiff, I probably don't know the answer. And so I would put in something like, consider this response. If you do know for an absolute fact a different response, you write it here. 70.5, has plaintiff's interest in the rental unit changed since the acquisition? If so, state the nature and dates of change. This question is basically asking the plaintiff a question. I'm asking this is check for you. It's asking you to get in the plaintiff's head and asking, has their interest in the rental unit changed since the acquisition? You can't get in the plaintiff's head, so you should consider the appropriate response. If you know for a fact some answer other than that, you put it here. It's a good way of, when you read a question, is the question asking me to get inside the plaintiff's head to answer? Because I can't do that. So I'm going to consider this answer for something like that. Or if for some reason you know some other answer, factual answer based on something tangible, you put that there. 70.6, are there other rental units on the property? And if so, state how many. This is a good example of a question that both the plaintiff and the defendant could easily answer. The information is readily available. It's right there. If you walk around the building, wherever you are, is it a single family home? Then there's no additional units. It's just one, unless they've separated the single family home into, other additional rental units. Um, if it's an apartment building, you could conceivably count them yourself, or you can go on Zemus or some other website that that covers rental properties. Zemus is great for LA City. It will tell you lots of helpful information about the property, whether it's RSO protected, TPA protected, laws that help protect tenants. And also it'll tell you the year the property was built, how many units are on the lot. And this question is specifically asking how many additional units in addition to yours. So if there were 100 units total, and there's 99 additional, 99 would be the number you put here, and you would check this response. If there are no other rental units on the property, you would check here. 70.7 is during the 12 months before the proceeding was filed, did plaintiff possess a permit or certificate of occupancy for the rental unit? And, this question can be tricky because, it seems like something that perhaps only the plaintiff knows the answer to, but the landlords are often required to post permits and certificate of occupancy in public places for all tenants to see. So they're usually posted in the common areas, someplace where all the tenants would pass during, daily in and out of the property. And, you should look to see if the landlord has properly posted permits and certificate of occupancy. If not, take photographs and videos, depending on the circumstances. And that's potentially some information that could be helpful in your case. If they did not post permit or certificate of occupancy. But this question is basically asking, did the plaintiff possess a permit or certificate? And you're either going to say, you don't know. For a fact they did not post it, that they don't have it, or some other response here. You're always going to put the response that is the most accurate, truthful for you. These are just suggested responses. $70.8. This question is asking about a last month's rent payment, a security deposit, cleaning fee, rental agency fee, credit check fee, key deposit, or any other deposit paid on the rental unit. And basically the question is saying, other than your first month's rent, was there any other money that you gave the landlord or property manager for one of these reasons? If so, indicate the reason up top here, the date you paid it, the amount you paid, the form of payment, who made the payment, who received the payment, okay? If you didn't make anything other than a first month's rent payment, you would check here. Everything else, you're going to check here and then indicate what it was you paid. Very often, in the old days, landlords used to collect first month's rent, last month's rent, security deposit. The last month's rent was meant to be the very last month that you occupy the unit. So assuming that eventually you move out, the landlord wants to have that last month rent already paid so that you don't just say, I'm moving out tomorrow, and they don't have time to find a new tenant. This last month's rent was protection for that because the landlord had that money just, so that to make sure you gave proper notice of moving out. Nowadays, they don't have last month's rent all the time. I don't even know if it's even legally allowed in all places. But if you did pay a last month's rent, because sometimes people paid a last month rent many, many years ago, then you're going to indicate that here. Security deposit, if you paid it here, cleaning fee here, you're going to put in each box whatever it is that you paid. If nothing, here. And then this section is about any tangible evidence you have to support these payments. So if you have proof of your payment of any of those fees, last month, security, etc., you're going to say, if it's in your possession, check here. This is basically saying, look at my attached exhibit binder. I'm putting those documents there. Any other response, you check here and write out your response. Form interrogatory 70.9. State the date defendant first took possession of the rental unit. Again, a question that both sides could answer. You're going to put the date to the best of your recollection. If you don't know the exact date, put on or about. If you're not sure, put on or about. You can put on or about a date or on about a month, whatever it is that you know about when you first took possession. Ideally, the date, on or about, is the best way to put it, just in case you're off by a day or two. Form interrogatory 70.10. State the date and all the terms of any rental agreement between the defendant and the person who rented to the defendant. Now, this is basically asking you for the contents of your lease or rental agreement. And this response here that the EDN attorneys have put in is basically saying, instead of typing out or handwriting all the terms of my agreement, I'm attaching my agreement here. As part of my exhibit binder, you can find it under Exhibit 101. That is my lease or rental agreement, and you can find your answer to your question there. All the terms of the agreement are in the attached lease or rental agreement. If you have a verbal agreement with your landlord, check here and just indicate the monthly rent that was part of your oral agreement. And then any other response other than this, you check here and respond here. 70.1, for each agreement in the pleadings, identify all documents that are part of the agreement, state each part of the agreement, not in writing, identify all documents that evidence each part of agreement, not in writing, and identify all documents that are part of each modification to the agreement. Okay. So once again, this is talking about the lease and the rental agreement and that you're going to attach as Exhibit 1. If you check this box, right, this means I have my lease. I'm including that. I'm also including evidence of my rent payments and communication between myself and the landlord, because those might provide additional evidence for changes in the agreement, even agreements that were not in writing. And an example of this is a rent increase. Sometimes the landlord would say, you know, your rent is going up in 60 days to this amount. And even though you don't have any tangible evidence of that communication because it was verbal, the fact that your rent payments went up and you have evidence of your rent payments with the new amount, right? You produce that evidence as Exhibit 102 is rental payments. Exhibit 103 is written communication between you and the landlord and or property manager. And you can see these exhibits, right, at the end and request for production of documents. Go down to the request for production of documents, you'll see they've explained, right? 101, the rental agreement. 102, rent receipts, proof of payment. 103, communication between the parties. 104, photographs of the interior, if applicable. 105, photographs of the common areas, right? Those are the categories of evidence. And so when you're doing the form interrogatories, right, you're going to be referring to those categories of evidence. Let me make sure. Okay. I think we're right around here. Okay. So you check this box if to respond to this, you have the lease and rent payments and communication between the parties. Because communication between the parties might include a notice that was either posted to your door, mailed to you, handed to you, that says something like a rent increase or some other change or some new agreement, something added to your lease that's above and beyond your lease, some change in an agreement, new agreement, you're going to put here. Any evidence of it. Sometimes things are discussed verbally, but there's tangible evidence of those agreements because people write to each other. Sometimes a landlord will write something about the new agreement some way, or the tenant writes something to the landlord, a text, an email, etc., that addresses the change. That's evidence of that change of agreement. You include it in your binder and answer by checking here. If the agreement is verbal, you check here, but you might still have tangible evidence of rent payments and some communication of any change in agreement here, text messages, notices, letters, emails. Or any other response that, if these responses don't apply, put your response here. Form interrogatory 70.12 is asking, has any person acting on the plaintiff's behalf been responsible for any aspect of managing or maintaining the rental unit or property? If so, for each person, state the name, address, and phone number, the dates the person managed to maintain the property, the person's responsibilities. Okay. So if only the landlord, if the landlord and the plaintiff are one and the same, and only that person had interaction with you or handled things like collecting rent or doing repairs, only the landlord, you would check here. If there's other people involved, including the landlord's family members or someone they've hired to be property manager or maintenance person, someone who handles, repairs, can be a handyman, can be someone who does the gardening or pool maintenance, anyone who does any work, right? You check here, and then to your best of ability, you fill this information out. You might not have all this information. Sometimes we only know the first name of a person, but that's what you're going to put in. You're going to put your understanding of the dates the person worked there, maybe how many years, or if you know a specific, this person was working there only the first year I lived there, you can put that there, and their responsibilities. What are the things they did? If they handled multiple things, you could write that here. If they only did certain things, like this person was the handyman, he would come and do the repairs, or she, you put that here. And you fill this out to the best of your ability. 70.13, for each person who occupies any part of the rental unit except occupants named in the complaint and the occupant's children under the age of 17. For all else, so anyone who's not named in the complaint, who's an adult, 18 or over, state the name, address, telephone number, and birth date, the inclusive dates of occupancy, a description of the portion of the rental unit occupied, the amount paid, the term for which it was paid, the person to whom it was paid, the nature of the use of the rental unit, the name, address, and telephone number of the person who authorized the occupancy, and how occupancy was authorized. It's a lot of information. This only applies if there is someone who's living in the unit who's 18 or over and not named in the complaint. Okay, so if anyone who's living in the unit is named in the complaint, you check here and we'll go to the next question. Otherwise, check here. Sometimes we have a roommate that's not named in the complaint, and you're going to put their information here. Name, date, name, address, phone number, excuse me, date of birth, dates of occupancy, portion of the unit they occupied. If they shared the whole space, you can put shared here, but if they just rented sometimes they just rent a bedroom, put that here. The amount they paid, and if it's like monthly, put the amount per month. The nature of the use, residential, if it's just to, live in. And then the name, address, and person of the person who authorized. Okay, so it can be an interesting question because during the pandemic, there was a period of time where it was protected. Unauthorized occupants were protected. They couldn't evict you based on someone who was living with you that wasn't authorized by the landlord or the property manager. And then in some places, there was protection beyond that for those people that had moved in. And so but you're going to put in here if the person was authorized to move in. And then below are some of the additional questions about how the occupancy was authorized, including the failure of the landlord or the plaintiff to protest after discovering the occupancy. This is important because if a landlord or property manager, sees that someone is living in your unit and still collects the rent, doesn't ask that person to move out, you want to make that clear that they failed to protest. That means they were definitely made aware, one way or another, and did not protest the person living there. If there's some other explanation, so verbally, in writing, failure to protest, or some other response. 70.14 is asking, have you or anyone acting on your behalf obtained any document concerning the tenancy between any occupant of the rental unit and any person with an ownership interest, managerial responsibility for the rental unit? If so, each document state the name, address, and phone number of each individual for whom the document was obtained, the name, address, and phone number of each individual who obtained the document, the date the document was obtained, name, address, and telephone number of each person who has the document. Once again, this is about the agreement, the rental agreement, the lease, and any changes made to it. And so you can put pretty much the same response here, check here. This tells the the propounding party that you're attaching your lease, the rent payments, and communication between the parties because you believe the question is answered in those documents. If the agreement about the rental agreement was verbal, check here. And for any other response, you fill out here. 71.1, was the notice to quit on which the plaintiff bases this proceeding attached to the complaint? And if not, state the contents of this notice. Okay, so this is basically saying you should have received a notice of some sort. 3 days to pay rent or quit, 30 days to pay rent or quit, notice to perform covenants or quit, notice to cure or quit, or so many days to quit. And if you received the notice, either served in person, posted on the door, mailed to you, some combination of posted and mailed, they want to know, was that notice you received at your residence, at your unit, was it also attached to the complaint? And if not, state the contents of this notice. If it was attached to the complaint, simply check yes. If no, you can check no and say, I'm attaching the notice that I received in my exhibit binder, which is being included with the request for production of documents. So if you check here, you want to make sure that you're including that notice as evidence. And then any other response, you check here and write it out. 71.2, state all reasons that the notice to quit was served, and for each reason, state all facts supporting plaintiff's decision to terminate defendant's tenancy. State the name, address, and telephone numbers of all persons who have knowledge of the facts. Identify all documents that support the facts, and state the name, address, and telephone number of each person who has each document. Now, when you respond to this question, you have to think about what it is in your knowledge. What are the facts as you know them, versus what you might be assuming or guessing, right? Because this question is technically asking the plaintiff's decision, right? What are the facts supporting the plaintiff's decision? Okay, so the question is designed mostly for the plaintiff to answer. However, if it's checked for you to answer, it's possible you either know factually the answer, or you think based on certain actions, based on information and belief, right? This can be based on something the plaintiff said or did. Sometimes you might have tangible evidence of that, sometimes you might not. But based on something they said or did, based on information belief, this is why I think the landlord is terminating the tenancy. If you don't know, right? You're not sure, you don't want to guess, you don't want to assume, check this box, right? This means it's not in your knowledge, but it's it's probably the plaintiff's reason for serving the notice are not within your knowledge. Here is where it's, you have information belief that maybe this is the reason the landlord is trying to circumvent, meaning to go around or to avoid um, um, complying with the rent stabilization ordinance. And the next one, similarly, based on information belief, desire to once again not comply with the rent stabilization ordinance, go around it, because they're trying to retaliate against you for some protected activity, right? And examples of protected activities can be things like, getting help from a tenants union to find ways that, to protect you from being evicted, can be reporting to LAHD or some other government agency bad conditions in your unit, ways in which maybe the landlord has not provided you with a habitable unit. If you report them and then the government agency comes out for an inspection, because you want it to be fixed, because you want to live in a habitable unit, because living in an uninhabitable unit can mean there's something there that has created some sort of health, security, safety risk that you don't want to be living in. You could be paying your rent and the landlord isn't providing their part of the agreement to provide you with a habitable unit. You can report the landlord for that because you want to get what you paid for. You also don't want to create any of these risks, to health, safety, etc. And they come out, they do an inspection, maybe they cite the landlord has to remedy the situation with a certain amount of time, and the landlord gets mad that you did this and tries to evict you. That's a retaliation, right? So if you have information and belief based on something like that type of activity, you check here. And these can be and or, right? So something might be like, I'm not sure, but I think this because of some reason. And you can always write in some other reason other than the ones here by checking and responding here. You should always put the response that makes sense for you. That is the honest, truthful, factual response for you. 71.3 is to list all the rent payments and rent credits made or claimed by or on behalf of the defendant beginning 12 months before the notice to quit was served. So you don't put the month the notice to quit was served, you put the months before that, and you list each month and whether the amount you paid, the date you paid, the form, was it a check, a money order, etc. Purpose, was it for rent? Period covered was, the month of May 2024. Payer is the person who paid the rent. And sometimes it can be, more than one person that paid the rent. Sometimes it could be a partial payment made on one date and another payment made on the next date. And so for each partial payment, you're going to put a new line and explain, and if you made two payments for May, the period covered would be the same, and the purpose would be the same. Maybe the form is the same, but the dates would be different because you made payments on different dates, and the amounts may be different because, unless you paid half and half, these two amounts might be different, but the total month, 1 month's rent. And you're going to do that for 12 months prior. And this is about providing tangible evidence of those payments. If you don't have evidence of those payments, you check here. If you do, you say, I've included them in my binder under Exhibit 102, which is proof of rent payments. If you have some other response, you put it here. 71.4. Did the defendant ever fail to pay the rent on time? If so, for each late payment, state the date, the amount of any late charges, the identity of all documents recording the payment, and for each, state the name, address, and telephone number of each person who has the document. If you always paid your rent on time, usually on the first of the month, you can check here. If you ever paid rent late, and paying rent late doesn't necessarily mean paying after the first. It means look at your lease and find out when the rent is due. Very often, the landlord will say the rent is due on the first. However, it can be paid no later than the 5th or some other date. Usually leases are written in with a blank line that they can put in a date in. But sometimes they just check the first of the month, meaning it has to be paid by the first of the month or it's late. It should indicate if they do assess late charges, it should indicate in the lease or rental agreement what that late charge would be. And if you did pay late, meaning after either the first of the month, if that's the date it's required, or after the grace period, then you're going to put the date you did pay and the amount of any late charge assessed by the landlord. During the pandemic, it was illegal to charge a late charge or late payment. And so if you were assessed a late charge during the pandemic, you want to make sure you've indicated that here. So always on time here, otherwise check here and fill out this information to the best of your ability. And then down below, it's asking for evidence of those payments. If you have them, you put it would be evidenced in your rent payments under Exhibit 102, and you would check here. Otherwise, if you don't have evidence, check here. Any other response, you would write it out here. 71.5. Since the beginning of defendant's tenancy, has plaintiff ever raised the rent? If so, for each rent increase, state the date the increase became effective, the amount, the reasons for the rent increase, how and when defendant was notified of the increase, and the identity of all documents evidencing the increase. If your rent has stayed the same throughout your tenancy, check no. Otherwise, check here and then indicate the date the rent increase went up, the amount it went up, and how were you informed. There's limits in many places, and there's ordinances, etc., that limit how much a landlord can increase the rent. And so you want to provide this so that the attorney law clerk team can look at any rent payments, any rent increases that were made to make sure they were all legal. There were no rent increases allowed during the pandemic. So if the landlord raised the rent during the pandemic, you want to make sure that you've indicated that here. Check all that apply down here. Plaintiff's reason for increasing the rent is not within party's knowledge, or you have evidence of perhaps the landlord was, made it obvious in some way that they're trying to go around a rent stabilization ordinance. Maybe they're trying to go around the ordinance for retaliation reasons. Maybe there's some other reason or explanation here. And then this section E is about providing evidence. Do you have tangible evidence of the rent increases in your rent payments? So if you have a rent check that was, you have rent checks that were, $1,000, and then the landlord raised it $100, and now it's $1,100. The rent payments themselves are evidence of the rent increase. You don't necessarily need to provide a notice from the landlord that says your rent is going up $100. It's evidenced through the rent payments. However, if you have both, that's even better. If you have a notice from the landlord that says the rent increase is effective on this date and goes up to this amount on that date, you want to include that in addition to your rent payments, so that you provide all the evidence you have about rent increases. 71.6, during the 12 months before the notice to quit was served, was there a period during which there was no permit or certificate of occupancy for the rental unit? If so, for each period, state the inclusive dates and reasons. And again, this question, is similar to the one made earlier about permit or certificate of occupancy. And you got to ask yourself, do you have this information, or is it something the landlord would know? If you know for a fact that the plaintiff lacks certificate of occupancy for the unit, you check here. If you have some other response, you put that here. And remember, landlord's supposed to post, information about permits and certificates of occupancy in common area spaces. So you can look there and take photographs. 71.7, has any person ever reported any nuisance or disturbance at or destruction of the rental unit or property caused by defendant or other occupant of the rental unit or their guests? If so, for each report, state a description of the disturbances or destruction, the date of the report, the name of the person who reported, the name of the person to whom the report was made, what action was taken as a result of the report, the identity of all documents evidencing the report, and for each, state the name, address, and telephone number of each person who has each document. And this is specifically about a report, a written report that you would have been made aware of in writing of a disturbance of some kind or destruction caused by you, another one of the occupants, or one of your guests. And if there was not anything that you're aware of, you check here. If you're aware of one or more specific reports, you check here and write it out. And then down here, this is about evidence of those reports. You have tangible evidence, you check it here and include it in your binder. Otherwise, check here. You've searched, but you don't have any in your possession. You have some other response, you write it down here. I'm going to take a 2-minute break just to get a drink. My throat's parched. I'll be right back. Form interrogatory 71.8 says, does the complaint allege violation of a term of a rental agreement or lease other than non-payment of rent? If so, for each covenant, put in the responses. Okay, so very often, if you have done something to break some term of your lease, you will get a notice that says perform covenants or quit, asking you to remedy whatever it is that the landlord is alleging you have done wrong based on your lease. If this doesn't apply, very simply check no and go to the next question. If, however, there is something that the landlord has alleged, then you write out what is alleged here, and then you put the facts as you know them here, meaning you have the opportunity here to say, I disagree with this that's being alleged, and this is why. You state the facts here. And then you put the name, address, and phone numbers of any person with knowledge of, either what is being alleged and or the defense for the or any facts about what's being alleged. You're right there. And then here is where you would say whether you have evidence, tangible evidence. You check here and you attach it to your binder. Otherwise, check here and explain. (71.9) Does the complaint allege that the defendant has been using the rental unit for an illegal purpose? If so, for each purpose. This question isn't often alleged and therefore not often checked. But if it is, if this box is checked for you to answer, if there's nothing that's been alleged illegal, no. If there is something, explain what's alleged, facts supporting what's alleged or against, defending against it. and name, addresses, phone numbers of all persons with knowledge. And then documents attached to your binder. Uh, if there's any other explanation, you put it down here. 72.1. Does the defendant contend or base a defense or make any allegations that the notice to quit was defectively served? And a defective notice is different than defectively served. Defectively served notice means it wasn't properly served to you. Either you didn't receive it at all, or it wasn't served the way it was alleged in the proof of service. And the notice to quit is usually Exhibit 2 in your complaint, and the proof of service is usually Exhibit 3. And you can read the proof of service to see how either the landlord or someone on behalf of the landlord or the landlord's attorney or a process server hired by the landlord's attorney, how they allege they served the notice, and was it served that way. If it says we posted it in a conspicuous place on this date and also mailed it, but they either didn't do either of those things or one of those things, you can say it was defectively served. Just, this is a yes or no question. Either you think it was defectively served or you didn't. You don't have to explain it here because they're going to ask questions about it next. So this is just asking, do you allege the notice was defectively served? Either didn't receive it all or not served the way it was alleged in the proof of service. Form interrogatory 72.2. Does plaintiff contend that the notice to quit referred in the complaint was served? Okay, this is a question for the question for plaintiff. Not often checked, but if it is, you're going to think about who the question is being asked to. Does plaintiff contend that the notice to quit referred to in the complaint was served? If so, state the kind of notice, the date and time of service, the manner, date and address of the person who served it, a description of any document or conversation between defendant and the person who served the notice. So if you don't know, because it's a question for a plaintiff, you can just check here. It's saying, I don't have knowledge of this, but I believe the information you're looking for this interrogatory is in possession of the plaintiff. If there's any other response, you check here and write it out. 72.3. Did any person receive the notice to quit referred to in the complaint? If so, for each copy of each notice, state the name of the person who received it, the kind of notice, how it was delivered, the date received, where it was delivered, and the identity of all documents evidencing the notice. If no occupant of the unit received the notice to quit that's in the complaint, you check no. Otherwise, check yes, and then fill out the document. And you can put in, sometimes the landlord gives multiple notices. Sometimes they make mistakes. They give one notice, they don't act on it. They give another notice that, maybe they either don't act on that one, but then maybe there's a third notice, they finally do act on it. You're going to write out all the notices, all the dates, what kind of notice there were, notice pay rent or quit, etc. Delivery, posted on the door, posted or in person, mailed, date received, and delivery location. If it's, in person, mailbox, door, wherever it was, how you received it. And then notices are communication between parties, and so would be part of Exhibit 103 in your notebook in your binder. Okay, if you have the notice, check here. Otherwise, check here and write your explanation. 73.1. If any rent, this next section, 73, is about malicious holding over, and it's not often alleged in the complaint. Okay, and so you should check to make sure it's not alleged, but most of the time it's not. And if so, if it's not checked, if it's not alleged, then all the responses to the ones that begin with 73, right? You should consider the response malicious holding over It's not alleged in the complaint, because that's the actual response, because these questions are about malicious holding over. But if it's not alleged, then just check. Malicious holding over is not alleged in the complaint. If it is, check here and write out your explanation. If any rent called for by the rental agreement is unpaid, state all reasons and facts upon which the reasons are based. These questions are not often checked because it's not often alleged, but sometimes they hope that you will just answer the questions anyway. Check them. Just check your complaint. There's a box about malicious holding over. If it's not checked, then wasn't alleged in the complaint, and you can consider that response. Otherwise, you write your response there. So same for this next group. But has any defendant made any attempts to secure other premises since the service of the notice to quit or since the service of the summons and complaint? If so, for each attempt, state the facts indicating the attempt to secure other premises, state the names, addresses, and telephone numbers of all persons who have knowledge of the facts, and identify all documents that support the facts. If it's not checked, which is most likely, you put this, you consider this response. Otherwise, you put this response and answer the question. 73.3, state the facts upon which plaintiff bases the allegation of malice. Okay, if it's not alleged in the complaint, check here. Otherwise, answer here. 74.1 is a new category. Okay, is there an ordinance or other local law in this jurisdiction which limits the right to evict tenants? This is a yes or no question. And in most areas in LA County, there is some level of protection for tenants against an eviction. The landlord can't just evict you for no reason. They have to have, there's some level of protection, right? In LA County, you should double check to make sure that in your specific area, there is some level of protection. It may not apply to you, but there's an ordinance or local law which limits the right to evict tenants. If it exists, even if it doesn't apply to you, you can put yes or no here. And the next question is about the specific laws. And we've listed some of them for LA City, LA County, and some of the incorporated cities within LA County. So you check the ones that apply to you. Some of these are ordinances based on the pandemic, which have since expired, but they're still ordinances that were passed that limit the rights of evicting tenants for a period of time. So you can still check them. And then the ones for incorporated cities are down here. Form interrogatory 74.3. Do you contend that the rental unit is exempt from the eviction provisions of the ordinances or other local laws identified in 74.2? If so, state the facts upon which you base your contention. This is a question for the landlord, the plaintiff. It's basically saying, do you believe, if this is checked? Sometimes the landlord's attorney will want you to check and answer this question. Hopefully you'll answer it in a way that helps them. But, if it is checked, right, and you have answered, yes here, because there's some protection, and you've checked something up here because there's some protection, then you would check no down here if this is checked. Remember, this is asking, is it exempt from those laws protecting, right? If the landlord checks here, knowing it's really a question for the plaintiff to answer, but they're putting it for you to answer, they're hoping you put something here instead. So consider your answer carefully, put the answer that's truthful for you. 74.4, is the proceeding based on allegations of a need to recover the rental unit for use by the landlord or the landlord's relative? If so, for each intended occupant, state the name, address, relationship to the landlord, reasons for occupancy, all rental units on the property that were vacated within 60 days before and after the date to notice quit was served. If this reason for an eviction, it doesn't apply to you, but not applicable. If the landlord is saying, I'm evicting you because either I'm moving in or one of my family members, relatives is moving in, then this box would may be checked by the plaintiff, attorney, or the plaintiff, and you should answer the question. And the answer may be that you are unable to answer, but the reasoning is in the possession of the plaintiff. Because most of the questions that are being asked here are questions of the plaintiff that only the plaintiff could answer. 74.5, is the proceeding based on an allegation that the landlord wishes to remove the rental unit from the residential use temporarily or permanently? For example, to rehabilitate, demolish, renovate, or convert? If so, state each reason for removing. B, what physical changes will be made, date the work is to begin and end, permit information, identify all documents. If this isn't applicable, the landlord isn't saying, I'm evicting you because I'm doing some major renovations to the unit. If that's not applicable, you check here and only answer if it's checked here. Very often it's not checked. If it is applicable, if the landlord is using this reason to try to evict you, you can consider checking here because most of this information is things that only the landlord would know. 74.6, if this is checked, is the proceeding based on any ground other than those stated here and here? So if it's not about the landlord or a relative moving in, and it's not about substantial renovations, what is the reason? And so if this is checked, it's either not applicable. Otherwise, you're going to write out the explanation here. The reason, state the facts supporting or opposing the ground, right? The ground for the eviction, the names of witnesses, and any evidence. And this is where you want to put in, if it's checked, this is your putting in your story. You know, this is what's being alleged, but this is my defense against that, what's being alleged. And you're going to put witnesses here, documents, check if you have exhibits, tangible exhibits, check here. Otherwise, check here and explain. 75.1 can often take some time, and you should be careful and thoughtful about responding thoroughly to this question. This is about repairs, bad conditions in the unit, and any bad condition you experienced during your tenancy. And the question makes it seem at first like maybe it's dealing with something, you know, that the government has to get involved in, you know, by saying, do you know of any conditions in violation of state or local business codes, housing codes, or health codes, right? And that's part of the question, but the rest of it is just conditions of dilapidation, you know, aging, you know, things weathered or aging, or other conditions in need of repair in the rental unit. Or, okay, so these things can either apply or not apply. As long as any one of these things apply, you write it down, okay? So don't think like, oh, well, you know, I don't know about this housing code or health code stuff, so I'm going to skip this question. No. Make sure you read the full question, read every question multiple times so you understand what the question's asking. This one is clearly asking, do any of these things apply, any combination, or even just one? And one of them can be conditions in need of repair in the rental unit or on the property that affected the rental unit at any time the defendant has been in possession. If so, state the type of condition, the kind of corrections or repairs needed, how and when you learned of these conditions, how these conditions were caused, and the name, address, and telephone number of the person who caused these conditions. If you're living in an immaculate unit that has never had anything need repair, check here. If, however, there has been something that is either worn over time or weather or broke, whatever the cause, you check here and you write it out. This is the bad condition. This is what I suspect the repair needs to be. And this is how and when I learned of that condition. And you can also put an explanation about what you did once you learned of the condition. I notified the landlord, I notified the property manager, this is how I notified. But there's another section coming up about notification, but sometimes it can be helpful just to put it all in one place here. And then you have it to already handy for the next questions. Because in this whole next section is about repairs. And so answering this question thoroughly, 75.1, is going to help you answer the rest. This is about the cause. If you don't know what caused the condition, you check here. If you do know what caused, put here. This is if you know the contact information for the person who caused the condition. Otherwise, you check here. In 75.2, have any corrections, repairs, or improvements been made to the rental unit since the rental unit was rented to the defendant? Now, this is often a question for the plaintiff to answer, but it's also something the defendant can answer because it's talking about repairs or improvements made to the rental unit, your rental unit. And so you can list if the landlord never repaired, never made any improvements, check here. Otherwise, if they did, and you can look to 75.1, right? These are things that needed repair, right? Were any of them repaired? You can put it in 75.2. The correction that was made, the date it was made, who made it. And you can indicate whether the correction was made, to your satisfaction, the problem, whatever problem it was, it went away, stayed away, or did they do some Mickey Mouse fix where they just tried to solve it inexpensively, perhaps even irresponsibly, or just not completely, and the problem came right back, or it was never even fixed. You can indicate that here. But you're going to also indicate any improvements. Maybe it wasn't something you complained about, but the landlord took on their own, right? Like sometimes the landlord will just post a notice in your door letting you know, like, hey, we're coming in 24 hours notice. We're going to be redoing all the windows, right? Sometimes they actually do nice things to, either improve the value of the property or the unit, or because they had to meet some code, and they have to comply, right? But if you know of any corrections or improvements, this is where you do it. If you have knowledge about the cost, you put here, otherwise here and explain. This is about whether you have documents to support anything you wrote up here. If you don't, you check here. If you do, you put them in your binder, you check here. Otherwise, you can put a response here. This is about permits. If you know anything about permits, again, this question is really often directed at the landlord to answer because they would know a lot of this information. You might not know it all. If you do know, if you don't know, right, not within your knowledge, you check here. If otherwise, you put your explanation here. Okay. 75.3 is did defendant or any person during the 36 months, the 3 years before the notice to quit was served during defendant's possession of the rental unit, notify the landlord or their rental agent of employee about the condition of the rental unit or property. This is very important because if you want to make a defense in your case, if it's a pay, rent, or quit notice, and your defense is that the landlord didn't properly maintain a habitable unit, and you listed a whole bunch of things in 75.1 that needed repair, the next question is, did you notify the landlord? Did the landlord know these things needed to be fixed? And because you really have to give them an opportunity to fix them. So here's where you capture the problem, how the notification was made by you or someone else, the date of the notification, the method. Was it verbal? Was it in writing? The person that was notified, right? And you sometimes there are problems that are that are on the property. It says rental unit or property or property, that there are some things that are in plain sight, right? Like there's no way the landlord or property manager didn't know about this unless they never visit the property. If it's in plain sight for everyone to see, and the landlord and or property manager had to have seen it, then you can explain that that is a reason for them. They should have been aware. You can write that as an explanation. Otherwise, you're going to put in, if it's something inside your unit and they never came inside your unit, it's up to you to contact them some way to say, hey, I've got this problem. Can you please fix it? And then you write that explanation here. And then you indicate whether you either don't have any evidence to support or you do. And if there's some other explanation, you put it here. 75.4, during the period beginning 36 months or 3 years before the notice to quit was served to the present, was the rental unit or property inspected for dilapidations or defective conditions by a representative of any government agency? If so, for each inspection date, for each inspection, state the date, the reason, the name of the governmental agency, the name and address of each inspector, and the identity of each document evidencing each inspection. Now, sometimes this is done without your knowledge, especially things that have to do with the common areas. And so if that is appropriate for you, you could check here, because you don't know, but the plaintiff might know. Otherwise, if you do know specific examples, right, that a government agency did an inspection, you check here and you answer the best of your ability. You might not have all this information, right? Question is designed for the landlord to answer, but it's checked for you to answer. You answer it to the best of your ability. Sometimes, tenants are the ones that file a complaint with the governmental agency. The government agency comes and keeps the tenant informed of, any violations, any notice that was given to the landlord to give them a certain amount of time to do the repairs, and any follow-up inspection. Sometimes that happens. If so, you can put that information here. And then this is about documentation, whether you have it or not. If you included it in your binder, you check the appropriate box. 75.5. During the period beginning 36 months before, 3 years, before the notice to quit was served to the present, did plaintiff or landlord receive a notice or other communication regarding the conditions of the rental unit or property, including other rental units, from a governmental agency? So this other question is about, was there an inspection, right? Did anyone come? Was the property inspected? That's what this question is about. This question is, was there any violations cited? Did the government agency give a report that said that something needed to be fixed? And so, did they receive any notification from a government agency regarding the condition of either the rental unit and or the property? Okay. If so, for each notice of communication, state the date received, the identity of all the parties, the substance of the notice of communication, the identity of each document evidencing the notice or communication, and name and address and telephone number of each person who has it. Okay. Sometimes we're not aware, but it doesn't mean it didn't happen, right? So you would check here, meaning I don't have any information, but plaintiff may have that information. Otherwise, you can check here about specific information you were made aware of. The government agency kept you informed, and you have information here. And sometimes it's a combination, right? You know what you know, but you don't know what you don't know. It's possible the landlord was cited for things that you don't know, even though there are things in your unit that you do know. Here is about producing evidence to support what you've written above. And so you would indicate that here. Either you have evidence and you include it in your binder or not. Next, 75.6. Was there any corrective action taken in response to the inspection or notice of communication identified in the previous two questions, 75.4, 75.5? If so, for each, identify the notice of communication, identify the condition, describe the corrective action, identify each document evidencing the corrective action. Might not be in your knowledge, but information with the plaintiff, check here. But if you are aware, check here and write out the answers. Type of notice, condition, corrective action taken. This is about supportive documentation. Either you have it or you don't. 75.7. Has the property been appraised for sale or loan during the period of 36 months or 3 years before the notice to quit was served to the present? If so, for each appraisal, state the date, appraiser, purpose of documents, etc. Right? This, again, if you don't know, but the plaintiff may know the answer, you check here. If you do know, you put the date, the appraiser, purpose here. If you have documentation, check here. Otherwise, here, write out your explanation. 75.8. Was any condition requiring repair or correction at the property or rental unit caused by the defendant or other occupant of the rental unit or their guests? If so, state the type, location of condition, the kind of correction or repairs needed, how and when you learned of these conditions, how and when these conditions were caused, the name, address, and telephone number of each person who caused these conditions, the identity of each document evidencing the repair or correction, the name and address and telephone number of each person who has the documentation. If this doesn't apply, you check no. If it does apply, answer all those questions here. F is about documentation. So if no, go to the next question. If you answered here, A through E, and you have supporting documentation you attach to your binder, here. Otherwise, check here and explain. 76.1. Did the plaintiff or landlord or anyone acting on their behalf do anything which is alleged to have been a waiver, a change, a withdrawal, or cancellation of the notice to quit? If so, state the facts supporting this allegation, the names, the addresses, and all persons who have knowledge of these facts, and identify each document that supports the facts. And so a waiver or change, withdrawal, cancellation of the notice to quit is when the landlord has given you multiple notices. Sometimes they make mistakes. Sometimes there's not mistakes, but they gave you a notice and they didn't act on it, right? If they don't act on it, right, then that changes your understanding of the agreement between you and the landlord. And there's what is it, consequences or ramifications. It can change the agreement going forward based on a new understanding. And I'm going to give you a most basic example of a waiver when it comes to a landlord and a tenant. In the landlord's lease with the tenant, it might say the the rent is due on the 1st. It maybe gives you a 5-day grace period. So if the payment is not received by the 5th of the month, you're charged $50 late charge. Let's say you pay on the 7th of the month, and the landlord says, you paid it, don't worry about it, I'm not going to charge you the $50. Now that's a change in the agreement. The previous agreement was in the lease, and it said After the fifth, $50 late charge. Now the landlord has created a waiver. He's saying that previous agreement based on the lease no longer applies. Now you can follow our new agreement, which is you can pay late, no consequence, right? Sometimes there is a clause in the lease or rental agreement that says, you know, that's specific to waivers and will say that they don't change the terms, right? So you read the lease. I'm not sure how good question for Elena is how good those kinds of clauses can be enforced. But a waiver can be a defense in an eviction case because it can apply in different ways, right? Your understanding of whether or not there would be consequences to some action based on a change in agreement can apply, right? It's something you can explain potentially during trial. You know, the landlord gave me this notice. It said that I had so many days to do this or quit. I wasn't able to comply for whatever reason, but the landlord didn't evict me. So when I got the next notice, and I wasn't able to comply, I thought the same thing was going to happen. I wasn't going to be evicted because I thought now there's a new agreement that's been established. That means the landlord gives me these notices, but nothing bad happens, right? So on the simplest level, that's what this question is getting to. Was there any change to the notice or waiver established that changed your understanding of the agreement and therefore the consequences? And so if it doesn't apply, check no. If it does apply, put your explanation here. If you have any supporting documentation, you put it here. Meaning I put tangible evidence in my document in my binder. Otherwise, if you didn't put evidence in your binder but you want to explain, you check that box and put an explanation there. 76.2. Did the plaintiff or landlord accept rent which is covered for a period after the date for vacating the rental unit as specified in the notice to quit? If so, state the facts, the names and addresses of all persons who have knowledge of these facts, and identify each document that supports the facts. And this question is if you get a notice to pay rent or quit, it's saying you must comply within this number of days. Could be 30 days, could be 3 days, not including the weekends and holidays. And so you look at when the notice expires, right? And then after it expired, say you didn't comply with the notice, right? It expired, but now you attempt to make a rent payment. You attempt to comply with the notice in some way. And the landlord either does or does not accept rent, right? And accepting rent is something you should discuss with a landlord attorney, like in terms of not landlord attorney, excuse me, your EDN attorney, about like if this circumstance applies to you, you should talk to your attorney law clerk team about how the payment was made and if it was actually accepted, meaning deposited. The check, like if you gave them a personal check that cleared, they cashed the check and it cleared, and they kept it for a certain period of time. They didn't return it to you, because this is a strong defense in an eviction case where it's a notice to pay rent or quit. Did the landlord accept rent after the notice to quit expired? That's what it means by period after the date for vacating the rental unit, because quit means vacate the rental unit. Okay, so that's what they're saying when they say period after the date for vacating. It means after the notice to quit expired. And so if the landlord accepted rent payment after that period, you want to itemize it here. If they didn't, you put it here. If you in some way gave it to them and they returned it, right? The answer is still no. As long as it was promptly and wasn't cashed, you can check no. If they did in some way accept it, or you suspect they accept it, but you're not sure, you can put it in here. You can talk to as I said, the law clerk EDN attorney team if you're not sure. Let them know how the rent payment was made, how you believe it was accepted, and then they'll let you know how to fill this out. But you put the date, who paid it, who received it, the amount, persons who have knowledge of the payment. Because if the landlord accepts rent after the notice to quit expires, if they legitimately accept it, keep it, that can reinstate your tenancy. So it's important to document it, have evidence of it, and talk to your attorney law clerk team about it. Put it in your PIP. This is, if you have no evidence to support, you do have evidence to support, and you put that in your binder. That would be like proof of rent payments, maybe communication between the parties, and then any other explanation you put down here. Okay. 77.1, state all the reasons the notice to quit was served or that the responding party's tenancy was not renewed. And for each reason, state all facts supporting plaintiff's decision to terminate or not renew the party's tenancy, etc. This is a question for the landlord to answer. However, if it's checked, you can put, if you have no knowledge, I can't get it in the plaintiff's head. I don't know why they did this to me. Could be lots of different reasons. I don't know them all. You can check here because you're basically saying, I don't have all the answers to this question, but the plaintiff does. But otherwise, if you can answer these questions, check here. If you know factually, check here and answer. And this is about documentation to support that answer. Either you have it, included it, or check here, no. 78.1. Did the landlord or anyone acting on the landlord's behalf agree to make repairs, alterations, or improvements at any time or provide services to the property or rental unit? And you're thinking, didn't we already cover, bad conditions and repairs above? Well, this question is a little bit different. This is asking if they did agree to make the repairs. You became aware of a repair that's needed. You notified the landlord of the repair, and one of those questions above. This is about, did the landlord agree and did they follow through? So you're going to want to make sure whenever you get these kinds of questions, read them multiple times so that you know what each question is asking you. There are often very subtle differences to these questions, but most of them are different in some way. And this one is about the landlord agreeing to make a repair, alteration, or improvement at any time, provide services to the property or rental unit. If so, for each agreement, state the substance of the agreement, when it was made, whether it was written or oral, by whom and to whom, the name and address of each person who knows about it, whether all promised alterations, improvements, repairs, etc., were completed, services provided, reasons for any failure to perform, and identify each document evidencing the agreement. Okay, so you could say, hey, my sink isn't working, I'm going to notify the landlord. You write the landlord an email. The landlord emails you back and says, I understand your sink is broken. I'm going to send someone out to fix it on this date. That's an agreement to fix it, right? Sometimes it could be verbal, sometimes it could be done by text or some other means, but you're going to write out how it was done here. If it doesn't apply, check no. If it does apply, check here and fill out the chart. And then hypothetically, right? So if F is where the repair is completed, right? You can put in whatever the explanation is here. Yes, no, and potentially, why it wasn't, or sometimes it's not just yes or no. Sometimes it's like, well, they came, but they didn't fix it. Like the problem came right back, or it was never actually repaired. And then here, you either know the landlord's reason for failing to perform the repair, or you don't, and you still can write out what you know here. Supportive documents, don't have them, do have them, some other response here. 78.2, has plaintiff or landlord or any resident of the property ever committed disturbances or interfered with the quiet enjoyment of the rental unit? When you lease or rent a rental unit from the landlord, there's an expectation that you get to enjoy that rental unit, that you get quiet enjoyment, undisturbed, no harassment, right? So If that's not the case, well, I mean, if that is the case, if you got it, if you have had nothing but quiet enjoyment of your rental unit, you can check here. However, if the landlord or someone else in the building has in some way disturbed your quiet enjoyment of the unit, noisy apartment, any type of noise or disturbance, sometimes people like can be, loud and violent, cause, really, really inappropriate disturbances on the property. You report them to the landlord. There's an expectation that the landlord will remedy that problem. You write out those stories here. Sometimes it's the landlord committing the disturbance, right? You might have a perfectly reasonable explanation for not being able to pay the rent, but the landlord is, harassing you, banging in your door at all hours of the day and night, calling and harassing you on the phone and whatever. Anything that's disturbing your quiet enjoyment of the unit, you write it out here. The description, the date, and any witnesses to it. And then if you have supportive documents here, you check, you include it in your binder. If you didn't, check here, any other response down here. And then down below, what action was taken by the landlord or plaintiff to lessen or end the disturbance or interference. If there was anything that they did, you write it out here. If they didn't do anything, or they are actually the ones, causing the disturbance, you check here. 79.1, has defendant or anyone acting on defendant's behalf offered any payments to plaintiff, which plaintiff refused to accept? If so, for each offer, state the amount, the date, the purpose of the offer, the manner of the offer, the identity of the person making the offer, the identity of the person refusing the offer, the date of the refusal, and the reasons for the refusal. This doesn't apply, check no. If there have been instances where you tried to make a payment, partial payment, check here and fill in the chart. The amount, the date of the offer, the amount offered, the date offered, the purpose, the manner, the offer, the offeree, the date of refusal. Sometimes when tenants fall more than 1 month behind, the landlord will say, I only can accept the full amount, right? You're trying to make one payment, but they were saying it's all or nothing, right? That would fall under this. Check yes. I tried to make this payment and it was refused on this date by this person. Whether you, if you have no knowledge, right, of why the plaintiff refused, put here. If you do have knowledge of why, you put in here. 80.1, does the defendant claim to have deducted from any amount which was withheld to make repairs after communication to the landlord of the need for the repairs? Okay. Section 80, all the questions that start with 80, let's say 80.1 or 0.2, 0.3, etc., right, have to do with what's called repair and deduct. Okay. And repair and deduct is something specific to a tenant having a problem in their unit that they communicate to the landlord and say, hey, I'm having this problem. The landlord saying, potentially, I don't have any way of getting that fixed anytime soon. And the tenant says, is it okay if I fix it myself or I hire someone? And they establish a relationship in which maybe they get some bids for the work. The tenant fixes it themselves or hires someone else to do it. And the landlord is involved in that process of, okay, I'm going to let you or someone else you hire fix it. And you can then deduct that amount from the rent. You fix it and deduct the amount, repair and deduct remedy, right? If repair and deduct remedy did never apply to you in your tenancy, then you check no to this. And then for subsequent questions for 80, the interrogatory does not need to be responded to because repair and deduct remedy was not raised as a defense. Okay, so when you get to the subsequent questions and you answered no here, then consider that no here, meaning this doesn't apply for the subsequent questions. This one is asking, did it ever happen? Yes or no? Next question, for each condition in need of repair for which a deduction was made, right? You're either going to fill out the chart based on what was discussed and agreed with the landlord, but if it didn't apply to you, if you answered no up here, you're going to check this box. This is what you should consider responding to, because this would be the appropriate response. If you didn't have that ever happen to you while you were there, a discussion with the landlord that you would somehow, or someone you hired, fix it and deduct from the rent the repair. Okay. If you did have that discussion with your landlord and you did deduct money from your rent to cover the cost, fill out this chart. And then you can put answers here, whether or not you have personal knowledge to the cost to remedy, or you did. Do you have personal knowledge of the bids obtained, or you didn't? That's what those questions are about. 80.3, did the landlord or plaintiff fail to respond with a reasonable amount of time after receiving a communication of need to repair? If it didn't apply, if you answered no to 80.1, you check here. Interrogatory doesn't need to be responded because repair deduct remedy was not raised as a defense. Didn't apply to you. If it didn't apply to you, this is the response you should consider. Otherwise, you should check here and fill out the response if the answer to this question is yes. Okay. Did landlord or plaintiff fail to respond within a reasonable amount of time after receiving a communication of a need to repair? For each communication, state the date it was made, how it was made, the response and date, why the delay was unreasonable. Does not come up often. These boxes are often not checked. If they are checked, you must answer, even if it didn't apply. And the response here is saying, to all these, this interrogatory doesn't need to be responded to because the repair and deduct remedy was not raised as a defense, meaning in your answer. If you didn't check repair and deduct remedy as a defense in your answer, you check this box. $80.4, right? Remember, doesn't apply. You didn't check it in your answer. It's here. 80.5 doesn't apply. You didn't check it off in your answer. You check here. 80.4 is asking, was there an insufficient period specified or actually allowed between the time of notification and the time repairs were begun by defendant to allow landlord or plaintiff to make the repairs? 80.5, does plaintiff contend that any of the items for which rent deductions were taken were not allowable under law, right? If you did raise repair and deduct as a remedy, then you're going to answer some other way down here, right? Down here. But if you didn't check it, which is most common, this doesn't happen very often. And one of the reasons it doesn't happen very often is, tenants have to be very careful about making repairs in units they don't own. You're renting, right? So the landlord owns the property, or someone owns the property other than you, I should say. And so if you make a repair to the owner's property, they can accuse you of making alterations to their property. So if you do that, you want to make sure you're very, very communicative. You've got it in writing. You establish that the landlord gave you permission. And so that's why it doesn't happen very often. And, if you didn't raise it as a defense, you check here. For this question, has defendant vacated, or does defendant anticipate vacating the rent unit because repairs were requested and not made within a reasonable amount of time? This is still about repair and deduct. This is still about the tenant communicating to the landlord. There is this repair that needs to be made, and the landlord saying, I can't do it. Can you or someone else do it? And this is about vacating the unit while that is being done. Okay. But if that never happened, you didn't check it as a defense, check here and move on to the next question. This is the last question about remedy and deduct. So if you answered no to 80.1, then you should consider the first response to each of the questions that fall under 80.2 through 80.6. Otherwise, answer the question. 81.1. Do you have an opinion on the fair market value of the rental unit? If so, state the substance of your opinion the factors upon the fair market value, which is base, and the method used to calculate the fair market value. This question is designed to be answered by an expert on fair market value. You know, most tenants are not experts on fair market value. And so, you know, you should consider this response, but if you have some other response, you put that there. And this is, you know, has any other person expressed an opinion about the fair market value? You know, if that's not the case, you check here. If there is a person who has, that's an expert, check here and explain. And the last question, 81.3, is very similar to 75.1, okay? So do you know of any current violations of state or local business codes? This question almost seems identical, right? To 75.1, and it is almost identical. And you can actually just use the answer to 75.1 here, right? So the only reason it's potentially different is 75.1 is about repairs that you know of. This question is about any repairs on the property, right? So there may be things from 75.1 that you're aware of, but there may also be other repairs, right, that you're not aware of that need to be made. Not necessarily, you know, most of the times we know about the repairs that need to be made on our individual units, but we don't often know problems in the common areas. And even in our units, there can be something that has happened to the building that affects our unit that we don't know yet, but we will know at some point, likely, but the landlord already knows. And so the reason why this answer is a little bit different from 70.1, it is to include what the tenant knows and what the landlord knows. So this answer says, yes, I know of some bad conditions that have existed in my unit and in the common areas, and I answered those in 75.1. But I can't answer all what this question is asking because some of the repairs to the building or my unit might not be in my knowledge, but in the plaintiff's knowledge. So that's why you check this if you answered 75.1. Okay. If you answered 75.1, you should consider this response. This says, look to that response for the answers I gave, and it's possible the landlord has knowledge of other repairs. Or you can say, I'm unable to respond because some of the information is not in my knowledge, but is in the possession of the plaintiff, right? If you didn't answer 75.1, you're not, like, sometimes we think we have a perfect unit. I didn't have to complain about anything, right? Everything in my house, it's, you know, maybe it's a newer unit, nothing's broken during the time of my tenancy, right? And so I didn't really have anything that I noticed, but maybe the landlord does. That's where you check this one. And you can just check no to the question, but you got to remember what you don't necessarily know is answered here. And then if 75.1 wasn't checked and you didn't answer it, you should answer the question here. In the same way you would have answered 75.1. And this is about whether you were aware of the causes to the conditions and aware of the people who caused those conditions. If the information is not within your knowledge, you check here. Otherwise, you check here and write out your explanation. When you get to the end of any section of discovery, it's very important that some response be on the page with the signature, okay? If for some reason, you know, the date is here and the signature is down here, you're going to want to push down, you know, by creating what we call widow marks. You know, like you probably have seen me do them like this. You can push down the response so that some part of the response that you have to put in is on the same page with the date and signature. It's important, okay? So you want to make sure that when you're done answering, the date and signature is on a page with some part of the response. Next is the verification page where you put in the name of the person who's responding, the date, the location, and then signature. And you want to make sure that if someone speaks only in a different language other than English, they use this verification saying that they are verifying that the information requested and the responses were translated to their language. And then the proof of service, which has to be filled out by someone who's an adult, 18 or over, not party to the action. The address, the date, how it was served, you got to put an X or check in each one. If it's emailed, you check here, you put the email address in here, the date of execution, signature here. It's important that the date of execution and the signature be done on the same date that it's sent. So don't wait till the last possible minute in the day, even though you can, like when the deadline is, 11:59 that night. No matter what the opposing counsel might tell you, like this needs to be in my office by 10 a.m. This needs to be done by 6 p.m. Whatever. No, you have to the end of the day to get your responses in. If the deadline falls on a weekend, Saturday, Sunday, or court holiday, it's due the next business day. And you have until the end of that business day, 11:59 p.m., to get the responses in. Don't wait till last minute because sometimes you can have technical problems, have to do something over, something's a mistake. You want to give yourself some buffer time, right? Try to get them done as early as possible. You don't want to even have to wait till the last day that they're due. You can get them done the first day that they're due. If you can, and get them done. Get them done and in so you have peace of mind. It's there, it's done. And if you miss the deadline, it's not the end of the world. Get it in the next day. Get it in the day after, right? You want to get it done so that you get it done before they write motions to compel. Now, motions to compel is, like I explained earlier, is a hearing date for the judge to rule on the motion. The motion is saying, I compel the defendant to answer these questions we propounded upon them. Well, hopefully, by the time of that hearing, you've already sent the opposing counsel the responses. In which case, sometimes they'll take it off calendar. If they leave it on calendar, they're hoping to collect sanctions, right? They're hoping to have the judge award them sanctions, a penalty, basically, a fine for you being late and them having to write this motion. They're going to argue it took us that we didn't get the responses on time. We wrote this motion, which took time for our firm, which cost us money, and we want to be paid that fine. And depending on the circumstances, the judge will either grant or deny those sanctions, right? They may also be claiming they didn't receive the responses at all. And you've got to speak up for yourself and oppose the motion, right? Or write out an opposition. Some judges, commissioners are sticklers about things being in writing, right? And we tend to know who those are. So if you receive motions to compel, make sure you let your attorney law clerk team know, because we could potentially assist you with opposing that motion. If they don't take it off calendar, we can also message the opposing counsel to say, you received the responses, can you take this off calendar? And sometimes they do. Sometimes they leave it on there to try to collect the sanctions. The sanctions on admissions are mandatory. So if you're late with the admissions and they file motions to compel on the admissions, motions to deem them as admitted, but say you did ultimately respond to them before the hearing, the motion to deem them admitted may be denied, but the motion to grant sanctions might be granted. So be aware of that. Sometimes these fines are hefty, like $1,500. You don't want to be hit with those fines. Don't delay. Get these done as soon as possible. Try to get help from your attorney law clerk team with the admissions. See if they have time to help you with the other parts too. Maybe a law clerk's not busy. See if the law clerk has any availability to help you with the rest of the responses, and you can keep coming to this class to learn how to respond to them yourself. Any question that you get stumped on, if you come to class today and you got, if you think, oh, okay, I have a better understanding, I figured this out, but maybe, tomorrow you work on it. Some of the questions haunt you in some way. I want to get more information about this question or that question. Come to the next class and, put your question in the chat and I'll try to answer it. If I can't answer it during the class because I've got to leave for some reason, you can always email it to me at mtarbox@edn.la. I'm going to put that in the chat. And send me your question. And what I would most appreciate more than anything else is if you send it to myself and Elena in a text, right? And that way she can supervise any response. If you're asking a general question, like, what is this question asking? Something I can probably answer. But if you're saying, this is in my case, I need to answer how, because in my case, this or that, right? If you start making it about your case, then an attorney needs to supervise the response. Could be that I can answer as long as the attorney is on the same thread and can supervise my response to say, that's correct, Mark, or no, Mark should have said this. That's why we avoid unauthorized practice of law. Most likely, if you ask a legal question, I'm just going to let the attorney answer anyway, because I don't want to have any examples of unauthorized practice of law. I only want to give you information about how to understand these questions. Like, what is the question asking you to do? It's asking you specifically to, it's trying to get this response, or it wants you to produce this documentation. Documentation is evidence. Okay. So, okay, let me now stop the video.